Good afternoon or good evening, depending on where you're at. I am Bob Mata, your host of Defense Diaries podcast, the place where we love to read documents and talk about the law and hang out, talk with friends, joke around a little bit, just have a great time. That's what we like to do. So, as you can see, my beautiful, brilliant co host is not with me as she still remains under the weather. I really almost guilted her into doing it again. She thought better of it though. And I cannot lie. I cannot lie. I picked the worst possible thing to decide to go over was reading these court orders because they are legendarily long. Legendarily long. Like if you put all of Judge Gull's orders together over 2 years, it would make up about 5 pages of one of these orders in the Kohberger case. So exactly, Mandy. Mandy knows. So, I really, really could have used my partner in crime, my partner in life, my partner in law, my partner in everything to help me read through this because they're just really long. They're so long. So is Jay live right now? Is that what y'all are saying to me? Is Jay live? I saw some shit like what? I do too. I hope she gets better too. It comes, it's an ebb and flow situation. She'll feel a little bit better, and then she'll start to feel like shit again. And the ebbs and the flows. So all right. Oh, he's going live in an hour. What's he talking about? Does anybody know? He didn't hit me up, so I don't know. Hold on. I gotta send this tweet out. Do we know what he's talking about? Squirrels. Makes sense. I think he really ran with my squirrel shit there, didn't he? If we're being honest, really ran with my squirrel shit. I had the squirrel battles, and I think Jay has really pimped my squirrel routine, man. But I'm good with it. I'm good with it. Jay's my brother. He can pimp whatever he wants. But really, what is he talking about? Yeah, I still have the squirrel issue. I've just elected not to whine about it anymore. What is Jay talking about? Does anybody know? Does anybody know? Can one person tell me what Jay's subject matter is? Wow. I'm going to take that as a hard no in the chat. Oh, you guys like that Ian, the Ian live? Yeah, that was fun. Awesome dude. Awesome dude. We had been planning on that for a long, long time. So I was glad that we were able to make it happen. It's that dance. I hit him in the DMs. He slides back into mine. And then the rose petal case and being a juror. No fucking way. Is that what I thought Jay left true crime. Just when I thought I was out, they pulled me back in. That's like, can't escape true crime. Can't escape true crime. It's everywhere. It's everywhere. So, all right, let's go. We had a couple of interesting things today. First and foremost, Luigi Mangione was in court, but it was on a state case. Remember, they're trying old boy in 3 different spots. Trying him in New York State Court on Moida, and they're trying him in the feds on the same thing, along with the gun charge. And then they got him out in Pennsylvania too. So what it sounds like in his, look, New York State courts, there is no cameras. So if anybody has designs on thinking that we're going to be watching uh Luigi Mangioni's case, we're not. We're not going to see it. And we're not going to see Humans. Those are not going to be streamed. So, we're going to have to go. But his lawyer did come out and she basically gave she gave a recitation of what happened inside there. So, and she said she's going to post the transcript of what happens after every court appearance. So that's good. So kind of the long and the short, she was out there. She did a little like 10-minute press conference. And she, was basically like, look, they're trying our guy in the court of public opinion. They're trying our guy in the court of public opinion. HBO's apparently got some kind of thing up there where they're talking about, evidence that they don't even have, they being the defense, in their possession yet. I call those fireside chats when the prosecution starts going on TV and sitting in comfy chairs and cackling, crackling fire, warming their hands. They have their pipe, can smell that cherry tobacco, swirls around their heads, open big leather bound books, and then start talking shit. So, she took exception to that, which she should, because it's bullshit. It's the same thing that they do in every case that's high profile. That's why I'm always saying, state's always getting their narrative out there first. I like that she's calling them out on the bullshit. That was the difference in Richard Allen and Karen Reed. The defense said, hey, you got your shit out there. We're going to get our shit out there, but we're going to have to do it through the use of emotion, which they did in a motion to dismiss and Reed and the Franks. But they got their entire theory of the defense is out there. So that you had battling theories. You're talking about a scale of justice. You should have both theories out there. Why does the government get to have their shit out there first? Forget about it. So, yeah, she railed on that a bit. I appreciated it as a defense attorney. I thought it was well done. Well done, counselor. And then we also had, which I was contemplating covering, but I had Allie take a peek at it, which was the DA with the Menendez brothers. And interesting. I asked Allie what she thought the vibe was, and the new DA was of the mindset. Sounds like it's pound sand. I warned y'all. I'm like, anytime you get a new DA in, you never know what's going to happen. Like, just because the predecessor DA thought that it was a good idea. And, I'm happy for Josh that he did that. Afton, thank you. Oh, you mean he was on local news in LA? Yeah, I wasn't surprised that this guy's taking a different approach. It sounds like it's a wait and see on the re-sentencing. He says they're going to put something in. They're going to put something in writing with respect to whether or not they're going to oppose it, or whether they're going to join in and say, hey, yeah, they should be resentenced. Allie said that they are in opposition of a habeas writ. I mean, that gives you a pretty good idea. I mean, just some of the things he was saying. He does not sound very, how should I put this? He doesn't sound very encouraging in terms of whether or not he wants these guys out. It sounds like he might think that they're exactly where they might be, or where they should be and should remain. And then additionally, he got into kind of the entire parole process and how that can go, and if they're eligible for parole through a resentencing, that there's still the opportunity for the state or the governor to shut that down, even if they're granted parole. So if you're the Menendez family, you're not walking away from that feeling great. You're just not. You're just not. Oh, hold on. I gotta send this tweet out. Um, I forgot to promote this little live. Okay. Okay. All right. Sorry about that, y'all. Yeah, I'm definitely going to be ready for Tuesday. Big day. Big day in Massachusetts. Over there in Boston. Boston. Gonna do Boston. We're gonna do a Boston Tuesday. Yeah, I'm ready for it. All right. So if you can't tell, I'm just trying to avoid reading all these orders on Kohberger. I'm really just trying to kill time till Jay starts, and then I'll say, oh well, I don't want to step on my homie's feet, like I'm gonna kill the ugh. All right, I can't avoid it anymore. All right. All right. Let's go. Okay. So let's just talk about. So there's Mandy yelling at me. I can't tell if it's Mandy or Allison. I don't even know if Allie's watching. She's probably not. Are you watching, Allie? Are you even watching in the other room? Are you supporting me from afar at least? Is Osbrook in chat? He's got the little Snoopy Red Baron emoji or whatever. What do they call these things? Profile pic? I don't know what they call it. I don't know what it is. You don't have to tell me. I don't care. I don't care what they call these little pictures. In the things I worry about in my lexicon, what they call those things does not rank. She is resting. She is resting. But I saw her resting with her little phone there. So maybe she's watching, maybe she's not. Maybe she's not. Man, he's always on fire. What do you mean tonight? Mandy's a fire queen, baby. All right, so let's go. Let's start knocking this thing out because with Jay going live in a good. I've already killed 45 or 15 minutes. He's going live in 40. Good job, Bob. All right. Okay, so first, hey Mandy, can you go in and can you set up the portal for Jay for us? So we're portaling over. All right. So first of all, I'm going to take all the drama out. If you've been living under a rock or you don't follow Kohberger, tons of motions have been filed in that case. As per usual in any criminal defense case, you're going to have your motions filed, your motions to quash, your motions to suppress, motion for Frank's hearing. So if you're not aware, the case was moved to a different county. Old Judge John Judge is no longer presiding. We've got Judge Hippler, who I actually, Crystal, that is the biggest crock of shit. Does anybody read more than me? Is there any law tuber out there that actually reads more than me? No, Peter reads. He doesn't read as much as I do. I don't know that there's any law tuber that reads as much as we do. Thank God I have Allie. Like, oh my God, I'm feeling her absence so massively. All right, so Hippler, like when we stream together, yeah, Emily does do a fair amount of reading. I still don't think she reads as much as I do, though. I think that's true. I didn't talk all that much with Ian though last night, did I, Arrow Lisa? Can control myself. Maybe what you guys should take from that is if I feel like if you think I'm doing a lot of talking, maybe I don't find the person that I'm talking to all that interesting. But if I shut up, maybe I find that person fascinating. Or maybe I just can't shut up. It's probably the latter. So, all right. But at any rate, so Hippler, I got the impression when we were streaming the last set of hearings and we went through those together that, people were trying to kind of read his, his facial expressions and the fact that he was doing this and, he had this going on. None of that shit mattered. Like I told you, like you can't try to guess what a judge is going through a judge's mind based on because he touches his face. Like this ain't that. So how you can judge what a judge knows and how a judge operates is by their court orders. That's how we don't know what Judge Gull does because the woman doesn't write court orders. She doesn't give opinions. Like, did we get anything in 2.5 years that is even remotely close to this? Oh, Marissa, you have to tell me when your mom's watching, so don't use bad words. Oh, what? Oh, your mom's watching me on Vinny, but she won't come over to my channel. Tell her she gets the real Bob here. That's like the cutoff. I've got 3 minutes to talk, Bob. And and tell your mom also Vinny's going to be on our show next week. She'll want to check that out. Not I mean. So, but the fact of the matter is that court orders really tell you a lot about a judge. And I'm here to tell you, as I was able to glean about Hippler last time, he's a good judge. He's a very knowledgeable judge. He's a thorough judge. What's up, T? Thanks for popping in, woman. Good to see you. Good to see you. So there were a bevy of, and I use that especially for Mandy because she liked when I used it in the description. There were a bevy of motions that were filed by the defense, most of them of the suppression nature. They did file requesting for a Franks hearing on the DNA stuff, and he denied all of it. He denied all of it, which means everything's coming in. Remember, judges are the ones who decide what comes in, what stays out. They are the gatekeepers of the evidence. And pre-trial, that is one of the primary functions that they're trying to figure out what's coming in, what's staying out. So everything's coming in. So I actually want to start with the order on the defendant's motion to suppress the genetic. You know what? I might pivot on this one. Like, I really want Allie to do the DNA one with me. Because she knows her shit when it comes to DNA. Mandy, I'm trying to kill time. Quiet. Mandy, quit yelling at me. All right, let's see here. Okay. All right, so that's the Franks. Let's do here. This one's good. This one's only 36 pages long. Let's see what's up. This one, they're all interesting. If you guys are not following Kohberger, obviously they were trying to keep the sheath out, DNA, which I don't care where you fall on this. I am telling you, it doesn't matter what squawking people out here think about touch DNA. It is powerful as fuck to jurors. It just is. If you think that some expert saying, oh, it's very easily transferred, you can't trust it, could have come from anyone. If you think that's going to matter, when they're presenting the fact that they found a sheath under one of the deceased girls with dude's DNA on it, that's not going to be an absolute gut punch, you're delusional or you don't understand how the court process works. It's a huge piece of evidence for a jury. Really does. I guess we're going to find out. We'll find out, innocence. Or maybe he didn't. Maybe he didn't misunderstand it. I mean, ultimately, if Kohberger gets convicted, it'll be up to the appellate courts to decide if he misunderstood it. That's really the only body that gets to tell a judge whether or not he misunderstood something and went beyond his discretion or committed flat out error. So let's start with the I'm not going to make comparisons to Richard Allen and Bryan Kohberger because I have very different feelings. No, I don't waffle. I've been very consistent on everything I've ever said. What Jennifer Fox, what do you think I waffle on? Tell me. I'm going to put you to the test. Put you to the test. All right, let's go. Intro. I'm going to look for your answer, Jennifer. I'll keep an eye. I'll keep an eye on the chat. All right. So, defendant is charged with 1 count of burglary and 4 counts of unaliving in the first degree in connection with the stabbing deaths of 4 University of Idaho students in early morning hours of November 13th of 2022. As part of law enforcement's investigation, the Federal Bureau of Investigation issued federal grand jury subpoena to Apple, to Amazon, to obtain information from accounts linked to the defendant. The FBI provided responsive information to detectives from the Moscow Police Department who requested and received search warrants for the Apple and Amazon accounts. In addition, detectives sought and obtained search warrants for defendants' Google accounts, a USB drive containing defendant's cell phone data, and for information held by the defendant's cellular carrier, AT&T. Before the court are the defendant's motions to suppress the information obtained through the subpoenas. Wait, did Jennifer tell me what I'm waffling on? I see a lot of waffle talk. Oh, yeah, because I don't waffle on jack shit. And my that sounds like troll shit. I'm very clear about where I'm at on everything, But the one thing that I always say, I don't pretend like I know shit for a fact because I wasn't there when crimes are committed. That's not waffling. That's actually just called the truth. I love waffles too. I haven't had a good waffle in like 8 years because they're so delicious and sugar bomby. They are delicious. As a matter of fact, I'm going to go make a waffle right now. I'll check y'all later. Oh, okay. All right. So before the court are the motions to suppress. Defendant argues that the FBI's issuance of the subpoenas constituted a warrantless search that violated his privacy interests under both the Fourth Amendment and Article 1, Section 17 of the Idaho Constitution. He further argues that the search warrants fail to command a search and or lack particularity. All right, so we got a footnote. Defendant also argued that the AT&T, Apple, Amazon, USB, and Google search warrants were invalid under Franks v. Delaware due to claims of recklessly or intentionally false or omitted material information and or because they were based on law enforcement's allegedly unconstitutional use of IgG. On these motions, defendants incorporated by reference his arguments in his motion for a Franks hearing and his motion to suppress regarding genetic information. The court incorporates herein its rulings denying both motions. Consequently, the order only addresses the arguments still at issue. Okay, so now do you know what they're saying there? So kind of the overarching theme of Ann Taylor is that the use of IgG was unconstitutional. It was in violation of Kohberger's rights. That search was just absolutely in violation of the Fourth Amendment. So now I've had a lot of discussions on this channel and on other channels about the current state of the law as to having a privacy interest in someone else's DNA. There's an issue of standing, meaning that if they were to go and pull some DNA, they throw it in some databases. And I'm not even getting into which databases they access. That's a different issue. There's so many issues with the use of IgG and just DNA and CODIS and the private databases. That's a whole different thing. Like we could spend hours talking about that, and we will, because it's a fascinating subject matter. But as far as the IgG part of it goes, it's really interesting because my position is, and it's not the law now, like right now you don't have standing, meaning I can't, like I've given you guys this example before, and it's that like kind of a classic example where, if I leave something incriminating in my friend's house and then they illegally search my friend's house and they find this incriminating thing that leads right to me and says, Bob did it. I can't go into court and file a motion to suppress that it was an illegal search because it wasn't my place. I had absolutely no privacy interest in my friend's apartment. So I lack what they call standing. Does that make sense? So, and that's currently where it's at with DNA. Now, what my broader argument is, which is not what the law is right now, is that DNA ain't that. Like if you're sitting in a restaurant, cops like you for something, you're drinking a coffee, you're eating a cruller, and you get up and leave. The cops dip in right after you walk out. They're like, ah, ah, we're gonna need those dishes. They pull out their little gloves, stick them on, get their evidence bag, drop the shit in. That is okay because the Supreme Court has ruled that you have abandoned that DNA. Okay, you've abandoned it. You have no longer claimed that you have a privacy interest because you left it in a public place for anybody to gather up. So that type of collection and DNA is okay. Now, when you're talking about IgG though, and the fact that we share, both men and women, we share DNA with our ancestors. Okay. It's a different thing. I think there is a valid argument that I have a privacy interest in my distant relatives' DNA because we carry the same DNA to a certain extent. Now, obviously, there's different strands. It's not all the same, but there's enough in a distant relative to be able to work your way back through the family tree, and they're making the connections. So and if Kohberger's convicted, I will put money that this case is going to be the one that brings the IgG issue up to the Supreme Court, and they're going to decide whether or not they believe that we have a privacy interest in our relatives' DNA. I mean, there's nothing on the planet that gives more information than our strands of DNA. Nothing. Nothing. It's out of everything that we should have privacy in, it should be our DNA. Now, I can't help that we share DNA with our ancestors. So I'm not suggesting that they can't use IgG. I want them to use it. It's super helpful in terms of cold cases, identifying old John Does and Jane Does. Do it. Do it. What I'm suggesting in investigations, get a warrant. Have probable cause that you've developed through other evidence that you've been able to collect. And at that point, then you can use it. It can't be your first step. That's just a massive a fishing expedition that I'm not cool with. So, but if he gets convicted, that's going to be litigated. It's going to be probably the biggest thing. So, point being that Ann Taylor has tied everything to the IgG. She's saying that she's basically making the same argument. And that's why she was fighting so hard to get all of the data from the IgG. They wouldn't give it to her. They were fighting. And ultimately the state kept saying, look, we're not using the IgG shit at trial. We're not doing that. You know why? Because we have Kohberger's we got his profile. We did a swab. We have his shit. She's like, I don't care about that. She's like, because when you move the thing backwards, you don't have any of it unless you illegally got a match through using IgG, which connected you to my client. Therefore, everything that you got after the fact is fruit of the poisonous tree. Starting with the arrest warrant. None of that should have happened. I mean, that's been her argument. in a nutshell. All right. So, and I mean, if you think about it, I mean, she's not wrong. But at the current state of the law, so, all right. So the state responds the defendant relinquished any privacy interest he had in the Amazon and Apple materials and further contends that the remaining warrants are proper and sufficiently particular. A suppression hearing on the portion of the defendant's motion at issue in this order, got another footnote, evidence and argument on the Franks motion and IGG motion were heard on the 23rd of January, 2025. The balance of the motions to suppress was taken up the following day. You guys remember we watched. So a suppression hearing on the portion of the defendant's motion at issue in this order was held on January 24th of 2025, during which the court received testimony from Detective Corporal Brett Payne and Detective Lawrence Mowry, both from Moscow Police Department. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because, one, defendant relinquished any privacy interest he had in the records subpoenaed from Amazon and Apple pursuant to third-party doctrine, and two, the remaining search warrants are valid. Now, let me ask you all this. And if you're lawyers out there, you'll know the answer. But do you think that the fact that Bryan Kohberger, through his attorney Ann Taylor, filed motions to suppress the Amazon and Apple data indicates that they have something that they're worried about that's in there? I mean, if there was nothing in the searches, what the fuck do they care, right? I mean, if there's nothing that you're concerned about them suppressing, Miku, don't be crazy. If there was nothing that that would be a frivolous motion. If there was nothing that they were concerned about that was incriminating, and they filed it anyway. Yeah, I'm not with Miko on the whole Bryan Kohberger thing. That dude gives me a vibe. I don't know what to tell you. I might be wrong. I have to wait till trial. Dude gives me a vibe. And not a good one. Not a good one. What's up, Sleuthy? What's up, ATS? Welcome. All right, so the standard review of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. State v. Valdez. A trial court's ruling on a motion to suppress evidence combines the issues of law and fact, and the trial court's factual findings will not be overturned unless they are clearly erroneous. State v. Conant. So when a decision on a motion to suppress is challenged, the application of constitutional principles to the facts found will be freely reviewed. State v. Benaroso. All right, so findings of fact. These are always the interesting ones. Yeah, definitely. It's good not to. I'm big not on convicting on vibes, but I don't like the comparisons between Kohberger and Richard Allen. I'll tell you that right now. At all. Very different cases. Very different cases. Okay, so on November 13th, 2022, an officer from the Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Madison, Kaylee, Ethan, and Zaina. Each appeared to have been stabbed to death. The investigation that ensued was a multi-agency affair involving members of Moscow PD and Idaho SP and the FBI, among others. For purposes of the investigation, a command team consisting of several investigators from each of these agencies was set up at the Moscow police headquarters. The command team included, among others, Detective Brett Payne and Detective Lawrence Mowry of the Moscow Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were co-located on the second floor of the Moscow PD. The command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. Did I miss three? All findings of fact. Ooh, wow. Ooh, ooh, wow. A lot of findings. Okay, so I'm going to read this footnote, which I've already missed. Okay, so the court's findings are based on suppression hearing testimony provided by Detectives Payne and Mowry, as well as the following documentary evidence. First, the first AT&T warrant. Okay. Boop, 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 boop. So the first warrant in State's Exhibit S1 and S2 attached to its objection to defendant's motion to suppress and memorandum in support regarding AT&T first warrant. Okay, so and then for the AT&T pen trap and trace warrant, defendant's Exhibit A's A and C attached to reply state's objection to defendant's motion to suppress and memorandum in support regarding the pen trap and trace. Okay, and then you've got the motion to suppress, or no, you got the for the Apple subpoena and the warrant, the Amazon subpoena and the warrant. I'm not going to read where they pulled they're just citing where they pulled them from for the Google warrants and for the USB. All right, I'm not reading all that shit. Okay, so for the purposes of the okay, wait, I read that already. So the command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. Pertinent information was transmitted into a working probable cause affidavit that could be and was incorporated by law enforcement into their various search warrant affidavits. All investigators had access to the search warrant affidavits issued during the investigation. Among the initial search warrants sought in the investigation were two to AT&T, a cellular carrier, for a phone number that law enforcement had linked to the defendant. Detective Payne applied for and received both warrants on December 23rd of 2022. As Payne was not an expert in cell phone data, he relied heavily on agent balance. The balance or balance? Balance. What do you guys think? Who is a member of the FBI's cellular analyst analysis survey team CAST and specialized in cell records analysis. Oh, see, he spelled it differently. Typo, Judge. Agent balance. So he's now with the typo. I'm just going to assume that it's balance because he misspelled it the way that you spell balance. He solved the issue for me. Agent Balance aided Detective Payne in both drafting the search warrant affidavits for the AT&T warrants and analyzing and returning information. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for the defendant's arrest. The arrest was effectuated on December 30th of 2022 at his parents' home in Pennsylvania. At that time, law enforcement seized defendant's cell phone pursuant to a search warrant for the home. To preserve the phone's data, the FBI copied the contents of the cell phone onto a USB drive, but did not review the contents. Law enforcement also had a warrant to search defendant's vehicle, which was located in the garage of his parents' home. During the search of the vehicle, a receipt for an Apple iPad was found. Interesting. Following the defendant's arrest, the FBI obtained and served two federal grand jury subpoenas, one to Apple, one to Amazon. Okay, so first warrant to AT&T. Payne applied for and sought 9 categories of records associated with the defendant's cell phone. 1 is customer subscriber information. 2, device purchase information. 3, associated email addresses. 4, call detail records. 5, cell site information. 6, cell site locations. 7, location information for the cell phone. 8, text and MMS messages. And 9, cloud data. So basically all the shit that matters. So each of these categories was narrowed by a detailed description of the specific information sought. All right, so like you can get the vibe, even though the judge has already told you that he's denied everything. You're getting the vibe. He's clearly laying out the specificity side of the warrant. Remember, warrants aren't free for alls. They have to be a very specific request of something that they're looking for. Let me see. If Bob had weird vibes, no more Banfield. I had to stop. Should be telling for Bob. What? What are you talking about? Gray Hughes makes sense of timeline based on his words because he saw no car other than headlights. I don't know what that is. I'm trying to I kind of want to read some of the chat. 'Cause I'm sure you guys are having a good time in chat. Chatting it up. Chatting it up. I get jealous. See, like when Allie's not here to read, then I'm missing all the chat. I want to read the chat. I do, though. The information requested was temporarily limited to a 48-hour period, November 12th, 2022 to 12 a.m. PST through November 14th of 2022 at 12 a.m. PST. In his accompanying search warrant affidavit, Payne set forth in detail the circumstances of the crime and the scope and results of the investigation as of that date, including evidence linking defendant to the suspect vehicle seen on the surveillance videos around the time of the murder. So Detective Payne indicated on how each of the categories of information sought would aid the investigation, including in determining whether the phone's activity was consistent with the suspect's vehicle route of travel as seen on the surveillance videos, whether the phone was in the vicinity of the murders during or prior to its occurrence as part of planning the crime, and why the defendant's phone was not reporting to the network during the estimated time of the crime. Footnote 4. An earlier search warrant had revealed the defendant's cell phone did not appear to be reporting to the network for the hour before and after the homicides occurred. Convenient. It's convenient. Or, as Andy Dufresne might say, Your Honor, I find that to be decidedly inconvenient, because if they found the gun, it would clear my name. Based on Detective Payne's search warrant affidavit, the magistrate issued a search warrant for records sought therein. The warrant stated in relevant part, Brett Payne, having given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crimes of homicide at 1122 King Road in Moscow, Idaho, is on the AT&T account associated with phone number 509-592. Hello, Brian? What's up, dude? What? You're in prison. You're not in prison, dude. You're in jail. What? Look, I gotta go. I'm unalive, bro. All right. So his phone number still works. It's cool. All right. So between November 12 of 2022 at 12 a.m. PST to November 14th of 2022 at 12 a.m. PST. The warrant then set forth each of the categories of information defined by Detective Payne in his search warrant affidavit. It was served by Mowry upon AT&T via email. As was Mowry's practice, he did not include Payne's search warrant affidavit with the warrant when serving it. AT&T emailed a return of the requested information back to Mowry later that day. The returned information was immediately turned over to Ager Balance for review and analysis. In reviewing the information, Balance had access to and knowledge of Payne's search warrant affidavit supporting the first AT&T search warrant. They call that the collective knowledge doctrine, kids. They have all kinds of tricks the cops can use. All kinds of tricks. Like Ian was blowing my mind like last night about how the Canadian courts are like, you know what? We're just gonna not go ahead and suppress that shit because that dude's guilty. We're just not willing to get rid of that evidence. I'm like, what? What is going on? See? Defense attorneys, man. U.S. Constitution. It's the best. It's the best. So B, the AT&T pen trap and trace warrant. Within hours of receiving the return on the first AT&T warrant, Payne applied for a second warrant to AT&T, this time to obtain records associated with the defendant's cell phone number for the prior 6 months, as well as for the installation of a pen register and trap and trace for the number. These records sought Bob, can you scroll? I am scroll. Oh my God, you guys aren't even seeing it. What the hell going on? See, all right, listen, ladies, Google Drive out. Shit's not working. Hold on a second. Let me see. I am scrolling. How do you think I'm reading it? The fuck? Let me see here. No, that's not it. I mean, how bizarre. All right. Oh, there we go. It was look, look. That was StreamYard. It wasn't me. I clearly was like, I cannot. No, I'm not high. I'm blind. I squint. I saw somebody ask, is it because I'm squinting all the time? Can't see shit. And my readers don't work this far. It's like I'm in a weird, there's a weird distance where the readers, that's too far from my readers and whatever. So, but my point being, I was obviously scrolling. I was very, I can't. I'm like so lost without. But Allie doesn't really do any of this shit. She doesn't do any of the tech shit. No, that was like, I swear to God, that was StreamYard. Because if I'm reading it, I have to be scrolling through it, right? So I was clearly scrolling. I'm glad I looked at that. My LASIK is old. It's like 15 years old. It's gone. Like I need to re-LASIK up, but I'm afraid to do it. I am lost, daughter. Where is she? Allie? Allie? Yeah. And I do read it through Adobe. All right. So after they get the first AT&T warrant, they go get a second warrant. They want for 6 months, as well as the installation of the pen register and trap and trace. The records were sought. The records sought were call detail records with cell sites for all voice, SMS, and data connections. So pen registers capture the outgoing phone numbers, email addresses, and other dialing or routing information transmitted by a cell phone. This is footnote 5. Trap and trace devices capture similar information that is received by a cell phone. So, okay, so these records were further defined to include subscriber account information, device identifying information. See, Hippler's being very careful to list the specificity. My sight glasses, I'm telling you, like this shit's too close for me to use my sight glasses or my readers. Like it's a weird like nether region. So like I really like last night my lighting, which I hate, is really bright. So I squint because it's like I have to like hide under my hat. Know what I mean? Know what I mean? All right. So device identifying information, usage, and location information to include cell site positions information, address of cell towers used by device, and subscriber identity information for customers who contact or are contacted by the device. So again, Detective Payne's search warrant set forth in great detail the circumstances of the crime and the scope. Yeah, I saw a comment. I mean, he's definitely, you could tell Hippler's a pro state, pro cop judge. Like, there's no doubt about that. I mean, which, if you follow the American jurisprudence system, you should know that's how they all are. There's very few exceptions. Very, very few exceptions. Okay, so Payne's search warrant affidavit set forth in great detail the circumstances of the crime and the scope and results of the investigation as of that date, including an analysis of the data received from the first AT&T warrant. This information, according to Payne, showed the estimated locations for the defendant's cell phone during the 48 hours before and after the homicides were consistent with the movement of the suspect vehicle seen in various surveillance videos. He stated, based on my training and experience and the facts of the investigation thus far, I believe that Kohberger, the user of the 8458 phone, was likely the driver of the white Elantra that is observed departing Pullman, and that vehicle is likely suspect vehicle 1. Additionally, the route of travel of the 8458 phone during the early morning hours of November 13th, 2022, and the lack of the 8458 phone reporting to AT&T between 2:47 a.m. and 4:48 a.m. is consistent with Kohberger attempting to conceal his location during the quadruple homicide that occurred at the King Road residence. As a result, I am seeking historical CSLI from June 23rd to current prospective location information and a pen registered trap and trace on the 8458 phone to aid in efforts to determine if Kohberger stalked any of the victims in this case prior to the offense, conducted surveillance on the King Road residence, is in contact with any of the victims' associates before or after the alleged offense, any locations that may contain evidence of the murders that occurred on November 13, 2022, the location of the white Elantra registered to Kohberger, as well as the location of Kohberger himself. A search warrant for the information requested by Payne was issued by the magistrate later that same day. The warrant stated in relevant part, Payne has given me proof upon oath this day showing probable cause establishing grounds for issuing a search warrant and probable cause to believe there are records related to the crimes of homicide at 1122 King Road in Moscow, Idaho, and are currently under the control of AT&T for historic call detail records for the telephone number ending in 8458 with cell sites for all voice, SMS, data connections between June 23, 2022 to present. Okay, so the warrant then set forth each of the categories of data outlined by Detective Payne in his search warrant. In addition, the warrant authorized investigators to install and use a pen registered trap and trace device and cell site simulator. Oh, I said stimulator. In accordance with IC 18-6719. Once issued, Payne sent the pen trap warrant to the feds for service since the FBI hosted the pen register portion of the warrant. Balance then served the warrant on AT&T on behalf of Moscow. And then Detective Payne's search warrant affidavit supporting the pen trap warrant was not served with the warrant. However, the return was provided to Balance, who had access to the search warrant reviewing the. So, I mean, you could tell the judge is going to rely on collective knowledge doctrine because Anne brought all this stuff up in her motions, that they were operating with creating affidavits, not knowing what the other cops knew, that they were just making shit up basically. So that's why the judge, he's foreshadowing what he's going to tell you in his rationale for his opinion. But at this point, I'm just here to tell y'all, like, there's not going to be any interlocutory appeals. It is what it is. Shit's all coming in, and it's going to be left to Ann Taylor to pick apart all the evidence, which frankly is how it goes most of the time. If people out there are under the impression that suppression motions are granted frequently, you have a misimpression of our system. They are not. Cops really got to screw up. They really have to screw up in order for a judge to grant it. I mean, because if you look at it from a circuit judge's perspective, a trial judge, that is, you got a case like this where you got 4 dead co-eds. You've got a major university in that town where it happened. Yeah, the judge is going to say in his mind, you know what? I'm willing to take the beating. I'm not suppressing this shit. I'm not going to be the bad guy here. I think the law supports it. And I'm talking about it in a close call, where it's a close call. And yeah, but gray space, get a law degree and come practice law, man. Like it is what it is. I'm not happy about it. I took a beating for 23 years in courtrooms. It's one of the reasons I couldn't wait to get out of it. It's like you realize in very short order when you get out of law school with, you know, open heart and wide eyes, and you want to go in there and change the system from the inside. It's just, I mean, these judges, bottom line, would rather have the appellate court go up there and overturn their decision and remand it, which is fucked up. Because if it gets remanded, that means that the victims' families have to sit through another trial. The taxpayers have to pay for another trial, which ain't cool. It ain't cool. I don't even, what the fuck is the dirt derble? I don't even know what that is. Oh, dirt devil. Derp derble? Why are you posting typos, Mandy? What's wrong with you? Jesus. Oh my God. Jay's starting in 2 minutes. I'm screwed. What is Jay's subject matter again? Can somebody tell me in the chat real quick? I wish Jay would have told me he was going live. Why just got to go live on a Friday, in the evening? Like for me, it's just turning 5. What, Mandy? Just tell me what it is. Quit busting balls and just tell me what the subject matter is. Derp derble. Let's see. Hold on. So Truth and Justice and Defense Diaries. How can they say that? I'm assuming you're talking about Dylan as a credible witness. She said she was drunk. Trial issue. It's a trial issue, Anna. You know what I'm saying? It's like that. Like, believe me, when that kid gets on the stand, they're going to go after her drunk ass, or her at that time drunk ass. They will make it an issue. It's a trial issue. That's not a, I mean, that is exactly what they have trials for, to vet the evidence. When I'm always saying vet the evidence, it's what I'm talking about, the credibility of the witnesses. Is the evidence, is it what they're purporting that it is? I mean, trust me, even though the DNA is getting in, and Taylor's going to attack the hell out of it. They're going to have their expert up there saying that it's a shit profile. I mean, the biggest problem is going to be that convincing a jury as to how his DNA got on it. I mean, the more likely approaches are going to say it's not his, that it's not a good profile. Because we the bottom line is we don't know the details of what they really have. It's like everybody gets all up in arms. Like nobody, none of us in here know. Because I'll tell you what, if the Amazon search shit shows that this dude bought the knife, it's done. Got news for you. I don't give a shit about the white launcher and anything else. If it shows that he bought the knife, and I don't care that they don't have the knife. If he bought the knife in the sheath, he's done. No jury's ever going to acquit somebody under those facts. Prepare yourself for that. And the fact of the matter is, we have no idea what other evidence they have. Melissa, it's what's her face? It's their DNA consultant. She happens to be an attorney as well. You talk about Bicca? I think it's her name, Bicca. Yeah, she's a licensed attorney as well, but she's also happens to be a monster at DNA, which is amazing. It's like what I was talking about. Wiki. Oh, he really is doing the rose petal thing? Oh. I thought you guys were kidding. I thought that was a big joke. And what do you mean a juror? What is he talking about with a juror? Did Jay get a juror? That would be amazing. What should I do, guys? Like, Jay's just coming back. I feel like he's playing pretend. What do you guys mean? I don't have ADHD. So I'm definitely not ADHD today. What I'm doing is trying to avoid reading 100 pages of court order. I love y'all, and I want to go through these. Like, to be honest, when I told told y'all I was going to do this, I really thought like Allie was feeling better. She was up and laughing, and then when I'm like, "Hey, I set the live," then she decided to get in the bed. She's like, uh. I'm like, "Oh man!" I'm like, "Dude, these are like massive." I've been going an hour. I'm only on page 7. Granted, there's been a lot of tomfoolery going on. I have to admit that. A lot of tomfoolery going on. I know, Jennifer, but I love Jay. I love Jay. All right, I'll keep plugging along. I mean, they do have replay crew, right? Yeah. Okay, so where was I at? So I'll just start with the Google warrants because I was yapping so much I forgot where the hell I was. So Mowry applied for and was issued 3 different warrants to Google between January 3 and February 24 of 2023. So again, he states that Mowry, having given proof upon oath, this day showing probable cause, establishing grounds for issuing a search warrant. And there is probable cause to believe that the property referred to and sought in or upon said premises consists of information related to the investigations into the crimes of homicide over at King Road. Okay. All right. So each warrant requests information in connection with the email accounts, phone numbers, and international mobile identifiers, the IMEI numbers that the investigation had revealed were associated with the defendant. The Google warrant issued January 3 of 2023 requested business records and subscriber information in connection with Bryan Christopher, 1994 at gmail.com, plus 2 phone numbers and an IMEI number. The Google warrant issued January 24 of 2024 requested business records and subscriber information in connection with whatever that means. You, sir, naming. That is username. Username. Huh. Has anybody figured out what the hell that means? I'm sure people have been deep diving. Why are you cricketing me? Why are you cricketing me? It is. It is. In the parlance of our times, it's a fuck ton. That's what it is. But look, it would be I'd be lying if I didn't say that I appreciate this judge taking the time to lay out whether you agree or don't agree. At least he's telling you what his rationale is. Do you see the difference? As opposed to him just denying shit without hearing. Denied without hearing. You can try to guess why I'm denying it. I mean, this guy makes a record. So the appellate court, in the event that Kohberger is convicted, is going to be able to fight it and raise the issues on appeal. It's how you do it. Everyone with AD knows. I do not have AD. I could sit there for 15 hours and never lose concentration. I don't. Maybe I do have ADD. I don't know. You guys, are you guys giving me some kind of diagnosis? Derble. Where's Cammy Q? Is she in here? Did you scare her off? Did I scare her off like making fun of her typo? Cammy, there she is. Oh, she's multitasking. Okay. I mean, I have to interact with y'all. That's not ADD. I'm trying to hang out with my friends here. You know, like me just reading. Boring. I like to incorporate both things. All right. So the Google warrant issued February 24th, 2023 requested data in connection with, quote, all Gmail accounts linked by recovery email, cookie, Android ID. Oh, was he a droid guy? Was he a droid guy? Creation IP or phone number associated with all of the accounts listed in the Google warrants 1 and 2, as well as for each of the 3 warrants were temporarily limited to January 1 of 2021 through December. Derp Derble. In addition, all right, listen, we need a Derp Derble emoji immediately. Use your creativity. Let's see. What do you guys think the Derp Derble should be? Is that, it's almost like Dirk Diggler, Dirt Devil, Derp Derble. Maybe it's a vacuum with the penis? Bingo, we did it. All right, so in addition, all 3 warrants listed the following 16 specific items to seize. All right, now we're getting into some shit. Google account subscriber information. Boring. Google account recent activity logs and connected. Mildly interesting. Google email messages, including drafts and those in the trash. Google Pay, account information and transactions, calendar events, contacts, people contact files, photos, videos, and albums, and associated metadata. I'm saying Derp Derble in the Hot Pocket jingle. Derp Derble. It's pretty good. It's fun. All right. Drive, documents, spreadsheets, presentations, and files, and associated metadata. Keep titles and notes. Hangouts and chats. What the fuck's a hangout? See, I'm so boomer. I'm not even a boomer, but I'm like starting to feel like a boomer. What's a hangout? What do you do there? Messages including attachments such as photos, location history, location data, and deletion records. My activity, searches and browsing history, including activity from web and app, activity, Google Assistant, and Google Home. Oh, man. So I've been writing, like I was writing the book before I started to do the pod. I was probably about 300 pages in. Of course, it's a fictional crime thriller lawyer book. But like the tech, which I'm sure you will find ironic, the tech is what fucks the criminal over at the end of the day. Like all the super techie shit. I know it's ironic that me, the tech wizard himself, would be diving into the techie aspect of that being the downfall of the criminal in my book. My plot point, though, it's fire. It's so good. It's so good. It's like it's really from the lawyer's perspective. So it's obviously the lawyer's the character. But there's a twist, a big twist. It's a big twist. Someday I'm going to finish that goddamn book. Mark my words. It's good. Like I was deep into it. That's the only reason that Allison let us stay in Arizona at the beginning of the thing. She's like, well, I mean, aside from like the pools, she's like, Bob's writing. It's like he's writing because we're out in Arizona and he's not stuck in the house in shitty Illinois. So like I squeezed like 3 months of Arizona at the beginning of the pandemic out because I was writing. I was enjoying it. Got deep into that mofo, I'll tell you. Should I go to work on it right now? Thanks, Mandela. Oh, boy. You don't think Bob sits around and makes ChatGPT stories? No. Like, I'm not going to lie. I feel like I'm starting to cave with the AI shit. Like, I'll fall so far behind in content creation, like all the shit that it can do, that I feel like I have to do it. Ah, what a hypocrite I am. Oh, Allie, like AI is actually her husband now. Like she has entire fucking conversations with that thing. And I'm like, wait, it's got like a real attractive voice. I'm like, what? Who the fuck? I'm like, she'll have like literal It's so bizarre. So weird. I'm actually getting jealous. Is that weird? All right, YouTube registration, email, channel ID, display name, IP logs, and account registration information. Android records for Android devices to include subscriber information, other associated accounts, cellular carrier information, and device hardware information. And Google Play. Google Play purchases made and Google Play applications downloaded. These warrants were each supported by search warrant affidavits executed by Mowry. In these affidavits, Mowry set forth a statement describing in detail the scope and results of the investigation to date, and how the accounts and phone numbers identified in each warrant were discovered and how they were connected to the defendant. He also included a detailed explanation as to how Google works. Wow. And why each of the 16 items listed in the warrants could be wrong. So here's how Google works. You put a search term in and then you hit send or enter. And then it gives you answers. Okay, upon receiving each Google warrant, Mowry served it on Google electronically through its law enforcement portal. Portaling. As was his practice, Mowry did not serve his search warrant affidavit in addition. Okay, well, his practice fucking sucks. Like, include your warrant affidavit. Like, how does this guy not including his affidavit in each additional to the each warrant? Like, include like it's bad practice. The returns for each Google warrant were submitted to law enforcement as a digital file available through Google's law enforcement portal. Payne downloaded each receipt or return upon receipt, after which he prepared a receipt and inventory of warrant. Mowry then reviewed the downloaded material to ensure it contained information for the correct accounts identified in the warrants before disseminating the returns to other investigators in the command team to process. It's awful. Swallow him. Do that. Each member of the team had access to these search warrant affidavits supporting the respective warrant. Thus, in processing the returns on the 3 Google warrants, the reviewing investigator was able to refer to the particular search warrant. So now we're down to the USB search warrant. So after the content of the defendant's cell phone was copied onto the USB drive, but not reviewed. Who's buying that? Who's buying that? So listen, here's what we're going to do. Okay, we're going to get all the content from dude's phone. We're going to copy it onto a USB drive, but we're not going to look at it. Okay? Got it? That's the plan. By the feds, the USB was sent to Mowry, who stored it in the forensic lab at Moscow PD. Mowry then applied for a search warrant or a warrant to search the contents of the USB. In his search warrant affidavit, he set forth in detail, same shit. Okay, so, all right, yeah, I got to start cutting the fat. Like, he keeps repeating the same shit over and over. So a warrant was issued that stated in pertinent part, Mowry, okay, same shit, probable cause to believe property consisting of a Seagate 2 terabyte external USB drive with serial number that for evidence regarding the investigation into the crimes of the homicides. Data compilations relating to or containing information indicating, suggesting, or related to violence, a fight, or motive, hostility for any of the same. To include without limitation ledgers, papers, lists, books, notes, letters, calendars, diaries, tapes, photographs, audio, video, and or other media or similar documents or items, computer and communication devices capable of storing electronic data, other electronic storage devices, and media, and access to contents of all of the above. Record of communications, written text communications, including emails, SMS text messages, MMS messages, and other communications, including, but not limited to, third-party applications such as Kik, WhatsApp, Facebook, and Instagram. Contact stored, location information stored in any cloud account associated with the phone. If sick, said account credentials can be obtained from the forensic image of the phone. Internet history, bookmarks, and or cloud accounts, written and audio recorded notes, or any cloud account associated with the device. Indicia of residency in or ownership or possession of the premises of any of the above items located in or upon the following described premises located in Latah County, state of Idaho. All right. So then he gives the addresses there. And then that boop, boop. We got that's the language from the warrant itself. So the USB was served on Mowry. Served on Mowry at the forensic lab. He then obtained the USB and prepared an inventory documenting his seizure of the USB. Oh my God. Bryan Kohberger's phone dead. Wow, this is like he is just he's laying out this reads like a probable cause affidavit. Like he's laying out every step. I've never seen a judge do this where they're laying out each and every step that the investigators took in securing their warrants. I mean, it's intense. Wi-Fi Army owns. Oh yeah, interesting. Okay, submitted the return to the magistrate, who in a subsequent order authorized the property to be delivered to any person or laboratory or laboratories for the purpose of conducting or obtaining any tests or analysis. All right. Okay, so enough of that. Apple subpoena, it's gonna be the same shit. I'm going until I find something that is not just a bunch of rote shit. And that's ROTE. So the FBI shared the information received from the Apple subpoena with Payne. Okay. Ooh. Should we read about the Apple fight? Hey, say what you will about Apple. I mean, they are definitely all up in our shit, which I don't appreciate. But at least they fight about giving our shit away.
You like apples? I got a number. How do you like them apples? That's pretty good.
Someday you're going to figure out that loop thing. You know? Someday, Mandy, you're going to figure out that loop thing. Like we're going to cut it off perfectly at the time where we're not getting the beginning of the loop again. Durable. All right, so the affidavit. All right, so Payne also conveyed that the defendant was seeking an advanced degree in criminology and had studied cloud-based forensics prior to the crimes. The affidavit discussed how defendant had attempted to conceal his location during the period immediately before and after the crime was committed. I mean, like, who thinks, like, if you're Kohberger, you had to have left the phone in the forest, right? You know what I mean? It's like, assuming that he's the guy. We're going to pretend in a world that he's the guy. He's the alleged guy. I mean, he's not, like, clearly he's not driving to the crime scene with the phone. So, like, his stargazing. I mean, if I'm Kohberger and I've got designs on committing these horrific crimes, I'm going to drive that mofo out to the forest and be like, yo, boop, stick it like on a tree, put it there. Yeah. Come back and get it a couple hours later. Durable. All right. So, Payne also included a detailed explanation about what types of information Apple captures. Payne has no idea what kind of information Apple captures. I'll tell you that right now. Seen men a lot smarter than Detective Payne that don't know a fucking thing about what Apple captures. I'll tell you that right now. And maintains from users of Apple accounts, and that he believed the information sought from Apple would, quote, provide information concerning Kohberger's plans, thought process. I mean, Apple isn't our shit. Apple actually can. It knows what I'm thinking. It's so annoying. So annoying. Research location, photos, or other pertinent information stored on his Apple account, including his iCloud account. A search warrant for Apple was issued the same day. So here's all the wordy words for that. So the information produced by Apple in response to the FBI subpoena is contained on the thumb drive submitted by the state as Exhibit S4 to the Apple objection. Objection! Apple don't like turning shit over. I mean, I like to think that it's for a righteous cause, but I think it's just because they don't want anybody getting in their shit. You know what I mean? I don't know. Durable. Okay, so the FBI's preservation request also listed other email accounts it determined might be associated with the defendant, but Apple's response to the request indicated it had no records associated with those accounts. Dude's a droid guy. He's a droider. He's not fucking with Apple. The Apple warrant set out 9 categories of information sought by Detective Payne in his affidavit and summarized. 1, account identification records. 2, records regarding devices associated with the accounts. 3, contents of emails associated with the accounts. 4, contents of IMs associated with the accounts. 5, the content of stored iCloud files, activity, connections, and transactional logs for the accounts. Locations where the accounts were accessed. Records pertaining to the types of service used. And 9, information necessary to decrypt any data. Other than its reference to the date of the crime being investigated, the Apple warrant was not temporally limited. And that's not temporarily, it's temporally. Okay, just so you guys get that distinction. All right, so the Apple warrant was served electronically by Payne through Apple's law enforcement email portal, as is his practice. Will be interesting how this goes down at trial since Cy Ray has BK in different locations than the cops. Will be interesting. I think I'm flying out for this one. I think I'm going to cover this one boots on the ground too. I think I'm going to do it. Not gonna do it. I think I'm going to do it. I'm thinking about it. If my wife will let me go. If my wife will let me go. I think you should walk, Mandy. How about them apples? I think you should walk. Yeah, them's fighting words. All right, so approximately 1 week later, Mowry downloaded the return provided by Apple and prepared and filed an inventory of the return with the magistrate. All right, and then we got all those words. Yeah, it's the same shit. All right, so Amazon subpoena is going to be substantially similar. All right, I'll skim through it, see if we got anything. All right, so conclusions of law. Finally, my God. My God. All right, you guys ready for some conclusions of law? All right, having already dispensed with the defendant's arguments regarding whether the warrants at issue in the 4 suspension motions addressed herein were invalid under Franks and or as a result of law enforcement's IGG investigation, which he obviously is not. So I've read this out of order. Don't be angry. Don't be angry. So he's already poo-pooed Ann's IGG arguments. And now he's going to tell you why else he says shit's not getting suppressed. So the remaining issues are as follows: whether the grand jury subpoenas violate the defendant's privacy interest in his Apple and Amazon accounts under both the 4th Amendment and Article 1, Section 17 of the Idaho Constitution, whether the AT&T, Google, USB, and Apple search warrants were sufficiently particular, and 3, whether the Google, USB, and Apple search warrants properly command search. The court finds suppression is not warranted on any of these issues. Okay. Interesting. Oh, by the way, so I screen grabbed last night. I screen grabbed everybody that gave supers. So I've got them all. So I think there were 7 individuals, and I think a couple people had a couple of entries. So I'm not going to do it tonight because I didn't set the goal, but I just want you all to know I kept track. All right. Free radical, we will have to agree to disagree. It's not entitlement. It's a privacy interest. I mean, it's like it's a great conversation. I want to have it, but like, as far as like phone records go, like there was an expectation of privacy that we obviously had in our phone shit. And the way that the Supreme Court got around it was that once it's getting sent off to a third party, i.e. our carrier, we lost that, even though we have to do it to have the goddamn thing operate. With DNA, spoogies, spoogs, derp derbles, derp derble, derp derp derble. Free radical. I love that conversation. Now is not the time though, but I promise we'll do a live on it. I'll flesh it out a little more in terms of and take a peek, free radical. Talk about if you just ask your AI to pull some information about there's a lot of literature out there, legal literature about the concept of what I'm talking about, that there is an expectation of privacy in our DNA as to IgG. There's camps out there. I mean, are you a big government person? I would think by the name free radical you wouldn't be. Make him get a fucking warrant. Simple. Get probable cause. That's how I feel about it. Have PC. Have PC that you got somewhere else before you go digging into our most precious information, which is our DNA. I mean, like, you just can't get more information about a human being than a fucking DNA strand, man. I mean, it's like, what? Get a warrant, and then you're good. If you don't have enough probable cause, you can't start with the DNA through IgG. That's got to be like a part of the investigation down the road, and you got to get a warrant. That's how I feel about it. I like your analogy there, hedgehog. I don't know that it is. I don't know if there is a distinction. Driving while black. To like, a lot of cops love that probable cause. Only problem is it's not probable cause. That's why I love Judge Fleischer. I keep meaning to like stream him occasionally, like get up early in the morning. We'll just sit there and watch Fleischer just rip people new assholes. Guy never wears a robe either. He's always got a bow tie on. He's great. Yeah, walking while black. All of it. All of it. I mean, first time I saw Fleischer tell a state's attorney when the guy was reading through the probable cause affidavit, like, and I can't even remember what the case was. He was like, "Oh, so your probable cause is he was driving while black." Okay, well, that's not probable cause. Go fuck yourself. And then, like, I'm quashing the warrant. Case over. I was like, I'm in love. I'm in love. I started emailing him, "Dear Judge Fleischer, do you mind if I use your Zoom stream every day of my life?" Yeah, it was great. All right. So, okay, however, a person challenging a search warrant has the burden of showing that he or she had a legitimate expectation of privacy in the item or place searched. So that's what we're talking about with the DNA. And that's what I'm saying right now, free radical, the law does not stand for this proposition. Right now, I would not be able to pull a case in support of my proposition at all. However, the way that the law works is we can change the law. We all know how many shitty laws there's been in this country since its inception. Thank God we have the ability to change law, right? And that's one of the things that kind of gets forgotten about. You know, it's like we're so focused on the existing precedent that, because it's a hard road to hoe to change law. You're having to change minds about the current state without having any supporting law behind you. You're having to convince people, like, okay, well, this is screwed up. We can't keep it like this. Shit ain't right. And it's tough. It's tough to change law. So that involves a two-part inquiry. One, did the person have a subjective expectation of privacy in the object of the challenge search? Put this to your DNA. You should have an expectation of privacy in DNA. You should. Now, you can't help that we share it with our ancestors. Why should that expectation of privacy disappear? Shouldn't. I mean, they can get to you from they can hunt you down from your relative's DNA. The first inquiry is a question of fact, the second a question of law. So one, the subpoenas did not violate the defendant's Fourth Amendment rights. Pursuant to the third-party doctrine, a person has no legitimate expectation of privacy in information he voluntarily turns over to third parties. That's what I was talking about with the phones. That's Smith v. Maryland. So this is true even if the information is revealed on the assumption that it will be used only for a limited purpose. U.S. v. Miller. There's Fleischer. Check him out. He's awesome. As a result, the government is typically free to obtain such information. He's so real. And he treats everybody the same. He treats everybody. He grills people. That dude does not see color, and I love him for it. Oh, it is back up? Oh, cool. We'll have to do that. I think one day a week we'll do some Fleischer watching, and you'll love it. All of you will love it. He will quickly become your favorite judge. I promise. Thanks, Mandy. Appreciate you, girl. As a result, the government is typically free to obtain such information from the recipient without triggering Fourth Amendment protections. Carpenter is really the watershed case on that, y'all. You want to read about why they can get into your phones these days? Carpenter is the place to start. So in Miller, the U.S. Supreme Court applied the doctrine to bank records in investigating tax evasion. The government subpoenaed the defendant's bank records, seeking canceled checks, deposit slips, and monthly statements. The court rejected the defendant's Fourth Amendment challenge because he could, quote, assert neither ownership nor possession of these business records of the banks. Moreover, the defendant's purported expectation of privacy was unavailing in light of the nature of the bank records. The checks were not confidential communications, but negotiable instruments to be used in commercial transactions. Like a check, writing a check and having a expectation of privacy in check is stupid. It's a terrible argument. That's a terrible argument. Free radically, you should feel that way about somebody trying to say that you have an expectation in a check that you've written, which you have to give to a bank or to somebody else to cash. So the checks were not confidential communications, but negotiable instruments to be used in commercial transactions, and bank statements were exposed to the bank employees in the ordinary course of business. Having taken the risk in revealing his affairs to another, that the information would be conveyed by that person to the government, the court found the defendant relinquished any Fourth Amendment protection. In Smith, the U.S. Supreme Court applied the doctrine to information conveyed to a telephone company. The court held that the government's warrantless use of a pen register was not, quote, a search. Petitioner can claim no legitimate expectation of privacy here. When he used his phone, petitioner voluntarily conveyed numerical information to the telephone company and exposed that information to its equipment in the ordinary course of business. In doing so, petitioner assumed the risk that the company would reveal to police the numbers he dialed. So you know what that means? We got to go back to the cans and the string. Mandy, pick up your can. Can you hear me? It's going through the string. Mandy. Phones don't work unless you go through your carrier. It's that workaround. It's crazy. It's crazy. We therefore conclude the petitioner, in all probability, entertained no actual expectation of privacy in the phone numbers he dialed, and that even if he did, his expectation was not legit. As the defendant notes, the third-party doctrine has come under increased scrutiny in the digital age. Thank you. Thank God. U.S. versus Moylan, noting commentators and two Supreme Court justices have questioned the continuing viability of the third-party doctrine under current societal realities. In her concurring opinion in U.S. v. Jones, Justice Sotomayor noted the doctrine is ill-suited to the digital age in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks. Think about how much your DNA. Think about that amount of information. All the shit is in your DNA. Later in Carpenter, the U.S. Supreme Court rejected application of the third-party doctrine to government collection of historical CSLI. In doing so, the court found two rationales underpinning the doctrine. First, whether the nature of the material revealed to the third parties indicates a reduced expectation of privacy. And second, whether there was voluntary exposure of the information to others were not fulfilled when applied to CSLI. With regard to the first rationale, the court noted that although one normally does not have an expectation of privacy in his movement on public streets, the pervasive tracking of movements revealed by historical CSLI was different because it provided a detailed chronicle of a person's physical presence compiled every day, every movement over several years. There's a world of difference between the limited types of personal information addressed in Smith and Miller and the exhaustive chronicle of location information casually collected by wireless carriers today. With regard to the second rationale, the court found CSLI is not truly shared as one normally understands the term. Rather, it is data that is generated by the user simply turning on the cell phone, noting that carrying a cell phone is indispensable to participation in modern society. The court found that in no meaningful sense does the user voluntarily assume the risk of turning over a comprehensive dossier of his physical movements. The court was careful to limit its holding in Carpenter to the facts before it, expressly declining to disturb the application of Smith and Miller in other contexts. While defendant recognizes this limitation, he argues that his purchase records from Amazon and data associated with his Apple accounts provides the same type of extensive private information that CSLI does. Footnote 11, defendant sets forth a laundry list of all the types of information Apple and Amazon collect on its users. So additionally, he points out that both Amazon and Apple are heavily regulated and contends that they guarantee their users' privacy. Consequently, he asserts that under Carpenter, a warrant is required for law enforcement to access this information. However, unlike in Carpenter, the dual rationales underpinning third-party doctrine support its application to defendants' Amazon and Apple information. First, in the nature of information obtained from the subpoenas cannot be compared to the exhaustive chronicle of location information at issue in Carpenter. The Amazon records consisted of his purchase history and associated account information for 1 year. The Apple records were even more limited, consisting of an account subscriber information and the date of the account was open. Like he wasn't using Apple. Hold on, I gotta turn this light on. I'm in the dark, y'all. I'm in the dark. Boop. I hate this light. It's so goddamn bright. I gotta kind of face the wall because it blinds me. All right. That's what I'm saying. Like, dude didn't have an iPhone. Like, if you're planning on like committing all kinds of crimes, like, don't buy an iPhone. Don't have an iPhone. Apple is all up in your shit. Smart criminals, they go Droid. Facts. It's facts. All right. So, moreover, this information was not generated by simply passive powering on the phone, as was the CSLI in Carpenter. It was voluntarily conveyed to third parties. The Apple subscriber information was generated by defendants' affirmative conduct in opening Apple accounts. Let's check out footnote 12, see what's up. 12, federal courts uniformly hold that subscriber information and other personally identifiable information disclosed to third parties are considered fair game under Miller and Smith. All right. Where was 12? Where was that footy? Where was that footy? Okay. The Amazon purchase records were likewise generated by the defendant's affirmative act in visiting the Amazon website, shopping for knives. Just kidding. Does not say that. Shopping for items, placing them in a shopping cart, and arranging for delivery and payment. Had he been shopping in a physical store, there is no question that under Miller, the security footage of him shopping and the transaction records could be obtained without implicating the Fourth Amendment. The fact that he was in a virtual store does not change the analysis. There you go, kids. Remember that. Remember that. All right. So, in addition, any subjective expectation of privacy he may have held in his Amazon purchase records and Apple subscriber information is unreasonable, given, according to policies cited by the defendant, both Apple and Amazon and Apple notify their customers that the personal information collected may be shared with other third parties and third-party providers. So he just cites the Amazon privacy notice, which we all have read. Have you guys all read the privacy notices? Ooh, send some my way, Marissa. I want some raviolis. What kind of sauce are you using? Oh, no, not a chance. I wouldn't know how to use it. It's like literally alien technology to me. I can't even figure out. I'm like, yo, dude, let me use your phone. Dude hands me a droid. Ooh, spicy vodka. Yum. Sounds delicious. Oh, Megan, you make the homemade sauce? So do I. Like a great marinara, super simple ingredients. Super and simple ingredients. Fresh garlic, fresh basil. The tomatoes are the key. Tomatoes are the key. If anybody in here can tell me what the proper tomato to use for a fresh marinara is, I'm going to pretend like I'm going to send you a sticker. One of these guys. Where are they? Oh, I don't know where they're at. They're here, and I'll pretend that I'll send you one. I haven't seen it yet. All right. What tomatoes do you use? She knows. She knows. Scorpion and Megan for the win. I actually owe Megan actual stickers. I was a BlackBerry guy back in the day. Allie would always get me like the new shit. I always had the new. Nope. Akasha, go to the corner. Always San Marzano. Always. Plus, if you go to Costco, you can get that ginormous can of San Marzanos that are delicious. I mean, technically, they probably are Roma tomatoes, but they're basting in fresh garlic or fresh basil. Yeah, Allie always got me the new. Like I had a TiVo. I was probably like the second person on the planet that had a TiVo. I think it was like a birthday. It's like right when we got out of law school. I'm like, what is this? Like, I don't know. She's like, but you always say you hate commercials, and this thing gets rid of commercials. I'm like, what? What do you mean? We hooked it up. We were TiVo people for a hot minute. Haven't watched a commercial since, except for sporting events. I can still remember the noise, that little TiVo bloops. It's probably why I love blooping so much. Bloop. Derp derble. All right. So in addition, any subjective expectation of privacy he may have had in his Amazon purchase records. See, I get to act like goofy when Allie's not here. Like Allie be like, you know what, dude? Cut the shit, bro. It's like, I want to go watch Severance. You. All right. So in addition, any subjective expectation of privacy he may have had in his Amazon purchase records and Apple subscriber information is unreasonable, given according to the policy cited by the defendant. Oh, wait, did I already read that shit? God damn it. Consequently, having considered both the nature of the information obtained and its voluntary exposure to other parties, the court finds no reason to depart from the third-party doctrine as applied in both Miller and Smith and concludes suppression is not warranted under the Fourth. All right, so here he's just gonna double down, saying that the Idaho Constitution affords no greater protection than the Fourth Amendment. Remember, y'all, is a general proposition. Really, Mags? It's super weird, but really good. Check it out. Oh, no spoilers, Michelle. No spoilers. Allie's like 3 episodes ahead. I like got into Landman. You guys watch Landman with Billy Bob? It's really good. It's really good. It's, Like Billy Bob just crushes the game. Guy's a great actor. If you don't think Billy Bob's a great actor, then go to the corner. You're punished. Punished. Yeah, me too. I was like, where the fuck do I remember her from? So I, of course, jumped on IMDb. I'm like, oh, I was like, I remember her first from here and probably best from Heroes. And Allie's like, oh my God. It's like Heroes. It's like, I can't even remember Heroes. I was like, oh my God, I know. How long ago was that out? Do you guys keep seeing they keep trying to like tempt me with rewatching Lost on Netflix? They keep throwing it up in my shit. Because we loved Lost, even though the show became Lost and had no idea how to end it, but like the first few seasons were awesome. I did. Sinead. I did. I'm a big trailer park guy. I love trailer park boys. I mean, rest in peace, Mr. Leahy. Andy, and the liquor. All right. So, Ed, what do you guys say? So, but see, I am ADD. I was like starting to tell you guys like a general proposition, then I forgot. I got sidetracked. Just kind of remember this: the U.S. Supreme Court. Now, I'm going to scrap that, strike that from the record. So, in terms of our Constitution, the U.S. Constitution, it sets the bar, right? So, you got your bar here, and then states can give us more rights. They can never give us less than what the Constitution affords us. Does that make sense? So, individual states can give their citizens more rights than the Constitution will provide, the U.S. Constitution, but they cannot give less. That's always the case. Oh, yeah. Goliath. Season 1, phenomenal. Season 2, kind of blew. Got back on the awesome train for 3 and 4, though. Like the last one, the opioid one was great. Was the last one the opioid one? I think so. Or were they all kind of opioid? Forgetting. It's all blending together. I've watched so many series. It's like crazy. Goliath season 1, was that the opioid one? Yeah, it was awesome. Or was the blowing up boat one, right? Was that one? I can't remember. Okay. So at times, Idaho's appellate courts have extended protections under Article 1. That's what I'm saying. States can give more that went beyond those provided by the Fourth Amendment. This greater protection has been based on an analysis of 3 factors: the uniqueness of our state, our Constitution, and our longstanding jurisprudence, State v. Donato. So with regard to third-party doctrine, though, Idaho's appellate courts have determined, with one exception, that protection under Article 117 is coextensive with the Fourth Amendment. The exception arose in State v. Thompson, where the Idaho Supreme Court rejected the majority reasoning in Smith and held that the use of a pen register constituted a search. In recognizing a legitimate and reasonable expectation of privacy in phone numbers that are dialed, the court, without any additional explanation or analysis, adopted and excerpted. Somebody read that word for me. The excerpted. Try to say that word right now. Not just excerpt, but excerpted. Okay, that has now become my most hated word in the history of words. You guys see it right there? Right there. I hate that word. Yeah, I hate it. The reasoning of Justice Stewart and Marshall in their dissenting opinions. Oh my God, they used it again. In his excerpted dissent, Justice Stewart recognized the vital role telephones played in everyday life and in intimate details of one's life. Dialed phone numbers may reveal, as well as the fact that a telephone call cannot be made without third-party involvement. So dissenting, Justice Stewart argued that constitutional protection should apply to dialed numbers as it was private information gained from surveillance, and the information emanated from private conduct within a person's home or office, both of which are constitutionally protected places. What about your car? Marshall's dissent focused on societal concerns. He noted that privacy in placing calls is of value not only to those engaged in criminal activity. The prospect of unregulated governmental monitoring will undoubtedly prove disturbing even to those with nothing illicit to hide. Hear, hear, Justice Marshall. So Thompson was later extended by the Idaho Court of Appeals to apply to the content of text messages stored by the service provider. Thompson. There, the court reasoned that if a protected privacy interest existed in dialed phone numbers, then by logical extension, it must also exist in the contents of text messages, which are far more intimate and private. Dick pics. However, Thompson has not extended to recognize protected privacy interests in other third-party contexts. In Donato, Idaho Supreme Court found the reasoning in Thompson did not justify broadening the protection under Article 1 to prohibit the warrantless search of garbage left at the curb for collection. The court reasoned that unlike numbers dialed on a telephone, which a person can assume will be recorded solely for the phone company's business purpose, trash left out for collection is knowingly exposed to the public view. True story, though. State v. Kloss, the Idaho Court of Appeals, consider whether defendant had a reasonable expectation of privacy under Article 117 in his power consumption records held by a public utility company. Finding that he did not, court noted that power records do not reveal discrete information about a person's activities, unless you got something that can be used nefariously that uses a huge amount of power. I think that power bills could be used to sniff some shit out. You always see your pattern, like, oh, your bill's like $43 more this month, and I know what it is. It's like, oh, I had to plug in the floor heater in Cam's room because she's over the garage and it gets cold as shit in there. So I know exactly what's causing that extra $40-50 a month. You could definitely ferret some shit out with electric bills. In finding that he did not, the court noted that power records do not reveal discrete information about a person's activities. They simply identify the amount of power usage. I would disagree, which could be caused by any one of numerous factors. Thus, the court found no constitutional basis for suppression when the utility company voluntarily disclosed these records to law enforcement. So finally, in State v. Mubita, the Idaho Supreme Court declined to extend Thompson to a defendant's laboratory reports he voluntarily released to a public health department to obtain HIV services, as well as the health department's own forms the defendant executed in seeking services. In doing so, the court found the records analogous to bank records in Miller by voluntarily turning over his lab records or lab reports to the health department and executing business records with the health department. The court found the defendant assumed the risk that this information would be further disclosed by the health department. Defendant posits that the massive amount of private information obtained by Amazon and Apple through user activity distinguishes this case from Donato, Kloss, and Mubita and fits squarely within the confines of Thompson. However, in determining privacy interest, the court must necessarily look to the information actually obtained, not what could have been obtained. What was obtained here was extraordinarily limited, namely a K-bar knife and a sheath. Kidding. Further, from a privacy perspective, the information is readily distinguishable from an individual's communications made from private phones. Purchases do not become deserving of constitutional protection. My dad's calling me. Oh, Bob. Oh, are you still unalive? Yes, Dad. Purchases do not become deserving of constitutional protection. Simply, he wants dinner. I guarantee it. Purchases do not become deserving of constitutional protection simply because they are conducted through an online platform with third parties. Likewise, there is nothing private about subscriber information a person voluntarily conveys to a third party in order to use its services. Indeed, if a person's health records voluntarily conveyed to the health department containing intimate information about the person's sexually transmitted disease were found undeserving of protection under Article 1, Section 17 of the Idaho Constitution, purchase history and subscriber information, which is far less private, falls well outside its protection. Consequently, suppression is not warranted under the Idaho Constitution. And then he's going to get into the warrants are sufficiently particular, which we know. We read them. I'm not going through it. He showed us. We read all of it. I don't care what you guys say. I'm not reading that shit again. It's, the particular, like you have to, in a warrant, there's got to be particularity. Like you can't, like it's, like I said, it's not a free for all. Like a warrant to search your home is not where they can come in and dig around in every nook and cranny of your home. They have to say what they're looking for, and they have to give an idea where they're going to look for it. And it has to be a place that would reasonably suggest that that would be where you would hide it. Right. I wasn't really on the phone with my dad. I was faking. Fair maiden. So, nah. You're being rude to me, fair maiden. Oh, sorry, fair maiden, for my fake phone call to my daddy. If the four corners of a search warrant are found not to be sufficiently particular, a search warrant affidavit may cure. Who dat? Oh, I think my dad's hungry. He called. I understand, but you're not now. Oh, okay. Okay, the accompany, let's see. If the four corners of a search warrant are found not to be sufficiently particular, a search warrant affidavit may cure such particularity deficiencies when the warrant suitably references the affidavit and the affidavit accompanies the warrant. Do you guys think that Fair Maiden actually thought that I called Bryan Kohberger too? Fair Maiden, were you on when I fake called Bryan Kohberger when they showed his phone number?
I don't even know what the fuck she's talking about. What the fuck is she?
That wasn't me. That was Mandy. She recorded that. That was from a voice memo that I left Mandy one time that she turned into a soundbite. Sweet.
I am your father.
The accompany requirement means the affidavit may either be attached physically to the warrant or simply be available to the search team for reference. Defendant's challenges to the warranted issue regard searches for digital data associated with the defendant's cell phone and Google and Apple accounts. While the particularity requirement is not usually difficult to apply to a physical world, courts recognize it is more challenging to apply to the digital world, as observed by U.S. Supreme Court. Cell phones with their immense storage capacities akin to powerful mini computers. I wouldn't say they're akin to it. They literally are mini computers, have become repositories of nearly every aspect of a person's life. And that comes from Riley v. California. Vigilance in enforcing the probable cause and particularity requirement is essential to the protection of the vital privacy interests inherent in virtually every modern cell phone and to the achievement of the meaningful constraints contemplated in Riley. So electronic data can be hidden in multiple formats and places in a cell phone or computer. Consequently, it can be difficult for law enforcement to specify in advance the sections of the device that should be searched. And that's coming from Adam Gershowitz, the post-Riley search warrant, search protocols and particularity in cell phone searches. So typically, particularity violations are found with regard to electronic information search warrants in two situations. One, where the search warrant does not state on its face what crime the search is being conducted to find evidence of, and two, where the search warrant contains overbroad catch-all language. All right, so defendants' challenges to the search warrants at issue focus on the latter situation. As he notes, a search warrant that simply provides an unbounded description of authorizing the search and seizure of any and all digital data will typically not satisfy the particularity requirement. In State v. Wilson, which relied upon the defendant, the Georgia Supreme Court considered a search warrant for a forensic examination of a murder suspect or that murder suspect's cell phone that broadly authorized the search of any and all stored electronic information on the phones, including but not limited to various kinds of electronic information. The search warrant included pre-printed boilerplate language stating that, quote, the foregoing described property, items, articles, instruments, and persons to be searched for and seized constitute evidence connected with the foregoing illicit crimes. See, now that is a perfect example of what is not particularity. It's just boilerplate, general language that will never pass muster. Never pass muster. Okay, so followed by check boxes where the affiants could choose among pre-printed statements generally describing how the object of the search was relevant. So he gets into Wilson bit, which we're going to skip. But you get the point. Like that language right there, no bueno. It's no good. It's just not good. Okay, so in opposing the defendant's suppression motion, the state relied on this pre-printed form language as limiting what is acknowledged to be otherwise sweeping authorization. The court noted that while such broad language may be permissible where the warrant contains a residual clause or other limiting language constraining the search to evidence of a specific crime, the pre-printed language provided no such limit. So it's recognized the Wilson broad language may be permissible where the warrant constrains the search to evidence of a specific crime rather than allowing a fishing expedition for all criminal activity. The rationale for holding that such warrants are sufficiently particular and not overbroad is that criminals don't advertise where they keep evidence. Indeed, a warrant authorizing the search of a house for drugs permits the police to search everywhere in the house because everywhere is where contraband may be hidden. Moreover, in the context of electronic devices such as computers and cell phones, criminals can and often do hide, mislabel, and manipulate files to conceal criminal activity, such that a broad, expansive search of the device may be required. Because law enforcement cannot know in advance how a suspect may label or code files containing evidence of criminal activity, by necessity, government efforts to locate particular files will require examining many other files to exclude the possibility that the sought-after data are concealed there. However, as the defendant notes, the inclusion of residual clause or other limiting language is not a green light for law enforcement to search in electronic files where evidence of the crime is unlikely to be. The major overriding problem with the description of the object of the search, any or all files, is that the police did not have probable cause to believe that everything on the phone was evidence of the crime of public indecency. For example, if there is a probable cause to believe that the evidence of a crime will be found in text messages, but not in photos, videos, or any other applications on the particular device, then a warrant allowing officers to access all the data in the device would violate the particularity requirement. So that makes sense, right? So if the circumstances of the investigation allow officers to narrow the search, a limitless search warrant is unacceptable. To this end, defendant cites to State versus Castagnola, I think, right? Castagnola, where the Ohio Supreme Court found overbroad a search warrant commanding a search for, quote, records and documents stored on computers without any limitation on what records or documents could be searched. This language, the court noted, did not serve to guide and control the searcher's judgment as to what was to be seized on the computer and included items that were not subject to seizure. Importantly, the court observed that the detective was able to articulate at the suppression hearing the specific records and documents he expected to find on the computer, yet he did not include those details in the search warrant affidavit. The court found that this degree of specificity was required since the circumstances and the nature of the activity under the investigation permitted the affiant to be this specific. So the cop screwed himself there by being very specific in the affidavit, and then he goes light on the warrant. San Marzano's aroma, but they're prepped different. They take the skin off, San Marzano's, and baste them with fresh basil. So delicious. So delicious. All right. Likewise, if circumstances allow officers to include temporal restrictions for a search of digital data, it may also satisfy the particularity requirement. In Wheeler v. State, also cited by the defendant, the Supreme Court of Delaware held that there were no facts in the search warrant affidavit that the crime at issue occurred prior to July of 2013. A warrant authorizing the search of the defendant's computer without any temporal limit was impermissibly overbroad. Moreover, even after determining the computer had not been powered on since September of 2012, the searcher nevertheless sifted through the digital universe, despite the fact the search would not have contained relevant material, or could not have if they hadn't turned the computer on. As in Castagnola, the court observed that although general classifications in a warrant are permissible, where a more precise description is not possible, if investigators are able to be more specific, such specificity should be included in the probable cause affidavit so as to appropriately narrow the warrant and mitigate the potential for unconstitutional exploratory rummaging. I like that. Unconstitutional exploratory rummaging. It's a good band name. All right, so the AT&T warrants. Okay, defendant asserts that are all encompassing. State responds are sufficiently particular. Court finds the warrants, even without supplementation by the respective supporting affidavits, satisfy the particularity requirement. While the warrants covered a broad array of digital information held by AT&T, they did not authorize a fishing expedition for any and all data, as was the case in Wilson. First, they were bounded by subject matter limitations. They were limited to a single identified cell phone number and contained a residual clause limiting the evidence sought to the specific crimes and address being investigated. In addition, the warrants defined specific categories of data to search and seize, which did not include all the possible data AT&T could have provided. Far from an any or all type of warrant, these warrants prescribed careful limits to ensure there was no question. It was called, where was it? It was up here. Unconstitutional exploratory rummaging. It's a mouthful, though. It's a mouthful. Real mouthful. Okay. Okay. Second, the warrants were subject to significant temporal limitations, unlike in Wheeler, which was devoid of any temporal limit. The information sought in the first AT&T warrant was limited to a 48-hour period immediately before and after the homicides being investigated. The second warrant was limited to the preceding 6 months, which was intended to capture information about whether the defendant stalked or surveilled the victims. Collectively, these subject matter and temporal limitations served to narrow the scope of the search and guide the discretion of the search team, thus avoiding unwarranted searches. Moreover, while the defendant claims that law enforcement was capable of greater specificity in the warrants as to what could be seized, he provides absolutely no support or explanation for this conclusory statement. Consequently, the court finds that standing alone, the warrant satisfies the Teal test, and suppression is not warranted. Moreover, to the extent the warrants standing alone suffer from a deficiency in particularity, the court find Detectives Payne's search warrant affidavits were sufficiently incorporated therein. And as mentioned, for a search warrant affidavit to supplement particularity, the warrant must suitably reference the affidavit, and the affidavit must accompany the warrant. So the AT&T warrants reference the affidavit by noting Payne. You know, they got that language in there. All right, so this is sufficient for the search warrant affidavits to accompany the warrants. All right, now the Apple warrant. Let's get down to that. So AT&T is good to go. With regard to the Apple warrant, defendant asserts it casts too broad a net, effectively allowing the search and seizure of all data from the two accounts. The state responds in particularity when considered with Payne supporting search affidavit, the Apple warrant imposed subject matter and temporal restrictions that were as narrow as could be reasonably expected given the nature of the investigation and the object of the search, i.e., electronic records. It's pretty good shit. All right, so the court finds standing alone, the Apple warrant satisfies the particularity requirement. To this end, the court finds two cases to be instructive. U.S. versus Palaio, which is a Ninth Circuit, recently rejected a similar challenge to a warrant authorizing the search of a defendant's iCloud. The warrant identified the accounts to be searched by the phone and the Apple ID. It also described the data to be disclosed by Apple and the evidence that the government could search for and seize. Although the warrant ordered Apple to produce the entirety of Palaio's iCloud account, the search and seizure of the evidence was limited to the identified crimes, i.e., drug-related crimes. And 21 specific types of evidence that the government could seize was limited temporarily to the evidence found after January of 2013. So the Ninth Circuit found the warrant was not a general warrant because it did not allow the executing officer to rummage through Palaio's iCloud account without discretion. I mean, how do you do that, though? Like, what if they're sending you all the shit from the iCloud? You're having to rummage through all of it to find the shit you're looking for, right? Or are they suggesting that Apple did the rummaging and then they decided what might be what the cops are looking for? Doesn't make any sense to me. I mean, you have to rummage. You have to look through all the shit to find what you're looking for, which means you have to get all of it unless Apple's doing it. So further, the court rejected the defendant's argument the government could have narrowed the warrant by excluding allegedly unnecessary information such as iTunes and iGames. It noted these accounts could have possibly contained evidence of a crime. The iTunes evidence of a crime. I mean, maybe you listen to some really shitty music. That is criminal, really. Even if they did not, the search and seizure of the data was obtained from Apple was limited to evidence of the specified crimes. So conversely, in US v. Pilling, said by the defendant, Idaho's federal district court found a warrant authorizing a search of a defendant's Apple accounts for the same information sought here were overbroad. The only limitation in Pilling was that the search of the account was limited to fruits, contraband evidence, and instrumentalities of violations. So conspiracy to defraud the U.S., false statements, obstruction of justice, or obstruction of agency proceedings, and witness tampering, and destruction, alteration of evidence. Court noted the warrant did not include the identity and nature of items to be seized and did not describe the items one commonly expects to find on the premises used for the criminal activities in question. Like, what are you looking for? Like, what are you looking for violations of the Clean Air Act? So although Apple warrant here is not as limited as that in Palaio, it is more specific than in Pilling. To satisfy the particularity, the warrant must at least minimally confine the executing officer's discretion by allowing them to seize only evidence of a particular crime. All right, so in Dickerson, a warrant authorizing a search for evidence relating to a broad criminal statute or general criminal activity, such as wire fraud, conspiracy, or tax evasion, is overbroad because it provides no readily ascertainable guidelines for the executing officers as to what items to seize. In contrast, a warrant authorizing a search for evidence relating to a specific illegal activity, such as narcotics or theft of fur coats, is sufficiently particular. Okay, I'm gonna skip that shit. Okay, so here, murder and burglary are specific activities, the planning and commission of which can generate distinct evidence. Further, while the warrant was not subject to a temporal limitation, the court does not find this fatal to the particularity. Namely, the subject matter of the warrant was limited to evidence of the burglary and or homicides on or about November 13th of 2022. This necessarily limited the time frame concerned and therefore the discretion of the searchers. Moreover, the Apple warrant only authorized the search of 9 specific categories of information from the Apple accounts. While these categories covered a wide array of information, some of the broader categories were subject to modifying provisions, such as contents of emails, in order to locate any materials referencing the planning or commission of the above offense, contents stored in iCloud in order to locate any potential source material or material created after the commission of the above offenses, and all activity logs for accounts in order to locate any additional connectivity between the suspect and the victims in this case. So then he makes the distinction from Pilling. By contract, there was no indication that the same 9 categories of information were similarly constrained. So the defendant asserts law enforcement could have been more specific as to what was searched and seized, but does not explain how. As many courts have correctly observed, electronic data can be hidden in numerous and varied formats to conceal criminal activity. Constant. There's no way. Like this all day is Hippler's law clerk. No way that he's sitting there drafting this shit. Not a chance. Or AI. Do you guys think that AI? Ooh, like how long before judges start using AI to write their opinions and to rule? Ooh, Napster. Good old days. The good old pirating music days. No way, Crystal. There's no way this judge wrote all this shit. I mean, the three orders are like a combined 80 pages. Okay, so this particularity true here, where law enforcement new defendant was seeking an advanced degree in criminology at the time of the homicides, had studied cloud-based forensics prior to the crimes. Thus, he was a highly sophisticated user, and could and likely would attempt to cover his digital tracks. Moreover, to the extent the warrant standing alone suffers from a deficiency in particularity, court finds Detective Payne's supporting search warrant affidavit was sufficiently incorporated therein. Okay, so he's saying the same shit. Okay, so in his warrant, Payne discussed at length the circumstances of the crime. All right. Gave a temporal range of October 7, 2016. The dates the accounts were created through the 30th of December, the date of the arrest. Thus, to the extent the Apple warrant was lacking in specificities, the search warrant affidavit cured it. Suppression is not warranted. I mean, as far as it's kind of hard to believe that like the only way that I can reach the conclusion that Kohberger was stupid enough to buy the sheath and the K-bar on his own Amazon account is that he was so confident that he wasn't going to get caught that he just didn't care about being careful. You know? Can you buy shit from Amazon as a guest? Like, I'm asking genuinely, I don't know anymore. I think you used to be able to. Can you buy shit as a guest, or you have to have an Amazon? You can. Is that the answer, Mandy? All right. So you can't, I mean, if you're buying the knife that you're going to be using in the commission of the crime, why on God's green earth would you use your own Amazon account on one of your own devices? I'm knee deep in that Amazon Prime shit too. They're all up in my business. All up in my business. All right, so now the Google warrants. Defendant challenges the Google warrants as representing an exhaustive list of everything that is available in Google accounts without any attempt to narrow, despite the fact that he asserts that law enforcement could have done so. He also argues in a conclusory fashion that not all the information sought in the Google warrants was supported by probable cause. However, defendant has not identified anything specifically not supported by probable cause. So the state responds that the particularly when considered with Payne's search warrant affidavits, the Google warrants impose subject matter and temporal restrictions that were as narrow as could be reasonably expected given the nature of the investigation and the object of the search, i.e. electronic records. Further, it argues the search warrant affidavit provided sufficient probable cause for the information sought. So the search warrant affidavits provided probable cause. Okay, so this is where he incorporated, the affidavits again. And Hippler is fine with if the warrant itself is lacking, he allows for the affidavit to supplement it. So Mowry's search warrant affidavits in the search of the Google warrants were far from bare bones. They provided an extensive explanation which we read. We saw them. I mean, they were pretty particular as to how the defendant was connected to the homicides, how Each email account, phone number, and IMEI at issue in the warrants were discovered and how they were linked to the defendant and why the Google data associated therewith could produce evidence of the homicide. So in the affidavit, Mowry discussed how the investigation led to the discovery of the two phone numbers, the IMEI, and he then outlined why. I mean, how do you carry the knife, dude? You ever seen a K-bar knife? Like, what are you carrying that if not in a sheath? It's a long blade, sharp as a mofo. I don't know how else you like. That's why I can't wrap my head around like how he would have forgotten it. Like, what the hell did he do with the? What did he do with the knife when he was done with it? Like bringing it out, unless he just had it in his hand still. Him, whoever committed the crime. Yeah, that's true. We don't, but you're gonna have a hard time convincing me that sheath just ended up there. And like, I'm not buying the planting of the evidence bullshit on this one. Sorry, not gonna do it. Not gonna do it. I don't think anybody planted it there. I know, like, everyone, but they didn't find it initially. Like, what? Come on. I don't think the girls had the K bar. It's pretty rare for like Garcia, our client was, he used he's convicted at this point, but he used knives from the house. Like that under their theory, that dude went to the crime scene or, both of the houses. Well, the first house at least without any kind of weapon. In the affidavit, I mean, Lisa, you got to think about like if that's your position, if they find out that he bought a K bar with that sheath, no, girl, no. You know, I can come up with some theories. That's a hard no on coming up with a alternate theory for that shit. Like in terms of a jury, he's going down. If his Amazon purchase shows that he bought that, he's done. 100%. 100%. No jury's ever given him a walk on that shit. If he bought the knife in the sheath that was found at the scene. Yeah, but are you a murderer? Do you murder people? I doubt it. You seem super sweet. I don't think you'd be murdering people. I mean, like the folks that like Kohberger's a weird dude. He's a weird dude, and I'm taking that from the shit that he wrote that we know was his. Shithead, dude. I mean, dude had issues, and his students hated him, which is very telling to me. My students would love me. They would love me. But I mean, you got to be a real jagoff to have college students hate you when you're like close in age. That's usually reserved for shitty, crabby old professors, curmudgeons. I mean, to be like a close in age and to have the students just think that you suck, probably suck. Doesn't mean he's a killer though. But I'll tell you what, whatever that snow thing he had going on where he wrote that diatribe, I don't know. I don't know. I don't know. You guys read that thing? If you haven't read that thing, I'll find it. We'll read it one day. I mean, I've sat in the room with sociopaths. You know what I mean? And what's that mean? It's not about like snow on the ground. It's like a condition he had. If that's what you're talking about, the snow. Yeah, no, it's not about weather, snow weather. It's about a condition. Have you guys read that? You guys know what I'm talking about? Oh, yeah, yeah, for sure. Yeah. Yeah, I kinda did, like, deep down. I kinda thought he was. You're talking about Zachary Hughes? I mean, I haven't I haven't had the opportunity to read his shit. So I don't know. Yeah, the visual snow. Thank you. Great Dane. Yeah. Have you guys ever read that? Let me know in the chat. It's pretty weird shit. Yeah, I hear you. Um, do you have any writings that you've written, beautiful messy, when you were in the midst of it? Send them over to me and let me compare and contrast. It doesn't make him a bad person. Have you read it, Megan? Have you read it? It's what he's saying in that worries me. Not that he has a disability. Oh. I no, hey, Mandy, I'm a lawyer. I like to debate. I like to debate. That's okay. It's fun. It's part of like we're not an echo chamber here. I mean, like there's going to be people that are not going to agree with me on cases. And like I said, I take exception to the fact when people are making comparisons to Richard Allen and Bryan Kohberger. I just do. Very much so. Like I am not on the camp of thinking that this guy probably didn't do it. I think he probably did. I reserve final judgment, obviously, until trial. He's a weird dude, man. He's a weird dude. I have probably an advantage over many of you, if not all of you, to having defended some really weird dudes and how they act. I don't know. Obviously, everybody's different, but you know, I don't know. Yeah, we'll have to see. We'll have to see what shakes out at trial. All right, so let's see. All right, so the Google warrant, I'm gonna skip through that. Found those particular for the same reasons. And he always says the same thing. He says that the warrants, where they may not be sufficiently particular standing alone, that the affidavits cure the deficiencies. So he's always leaning on the affidavits, which is allowable as long as they're incorporated properly. So in these affidavits, Mowry set forth a statement describing in detail the scope and results of the investigation to date. We've seen the probable cause affidavits. So, um, and those are all going to be challenged at trial. I mean, the bottom line here, like the bigger takeaway from everything being denied and nothing being suppressed is, and Taylor's going to have to do what every criminal defense attorney has to do all the time. You're going to have to pick apart the evidence piece by piece. You know what I mean? That's it. So, MB, how do you separate pretrial knowledge and waiting for what's to be allowed? Well, what do you mean? Like in turn, like, are you talking about in terms of prep? You, as a defense attorney, you assume the worst. You assume that it's all going to be admissible. I mean, if you're going through and you see just an absolutely blatant, because you really need to have a blatant violation of the Fourth Amendment in order for a judge to suppress evidence, especially in cases like this. Like they're just not going to do it. Like, and if they they will look for every feasible explanation or doctrine that they can to allow it in, whether it's good faith exception or the good faith doctrine or inevitable discovery. They'll always try to find a way to allow it in, and then they'll take their chances with the appellate court. That's what I was saying earlier. It's judges in cases like this that are on the bench just are not often willing to allow a guy to walk when in their estimation there's powerful evidence of guilt. All right, so let's see. Yeah, so this is all the same shit. Okay. So these are all the things that were denied. Motion to suppress the AT&T, the pen and trap and trace. So this tells you everything that's coming in. It's all coming in. And if you're wondering if there's a way for them to, I mean, they like Ann Taylor can and probably will file a motion to reconsider. Maybe just try to bulk up some of the arguments, but in a motion to reconsider, like waiting to make your opinion, you've got more than the jury will ever see. Well, I mean, as a defense attorney, as a lawyer on either side, your opinion doesn't matter. I mean, you're doing the job. I mean, it's like the same thing. Like there has to be prosecutors that, like, through the middle of trial, realize that they have a shit case and shit evidence, and that they just plow through. And it's the same with the defense. I mean, like Ann Taylor knows exactly what they have, way more than any of us do. I mean, we're all sitting here speculating about what's contained in the evidence. We really have no idea. We know the broad strokes. We don't know any of the nitty-gritty at all. None of us do. That's why, like, I don't get into the huge debates about it, about whether he's innocent or guilty in terms of like knowing it, because we can't know. So we don't know what the evidence is at this point. What my point always is when I'm saying, like, I'm looking at what they're claiming that they have, and it leans guilty in my opinion. And you all know me, like, like if it's on the fence, I'm going to have it lean innocent. Like, to me, this wasn't a fencer. To me, like they're going to have, like, I don't find the year screw up on the vehicle very compelling. I think it was him driving around, and I mean, we're going to find out. Look, my hope is, as it is with every case, anytime they're convicting somebody, that they have very powerful evidence. Very, very powerful evidence. Like I never want somebody getting convicted on bullshit. Ever. I don't want that to be the case. It's the worst possible scenario, because then you can't trust the verdict. But my point on this case is that they seal everything. We don't know a goddamn thing what they have. We really don't. All we've got is what we've been able to glean from the returns the search affidavits. As like, I mean, we know what they've gotten, and we know that at least on the forefront, like doesn't appear that they found any kind of biological in his vehicle or his apartment. He had a long time to clean. Just did. It's like there's going to have to be more. It's like Ann Taylor's obviously going to like heavily rely on the fact that there was DNA found on the railing in the form of blood, that there was DNA found on a glove outside in the form of blood that do not match the defendant. She will lean heavily into that. The state will make the counter argument. It's a party house. It's got college kids. Can't age the blood. You don't know how long it's been there. How much blood is it? Is it a small drop? Is it a smear? I mean, it's like we got to wait to trial to hear all that stuff. I mean, to me, the searches, and like the parents don't know either. Like you see Steve out there on shit all the time talking about it. It's like he's not privy to all the evidence. They just don't tell victims' families the evidence. It's not the way law enforcement works. They just don't do that. So we're all kind of sitting here speculating. That's why you can only go so far in terms of pretrial, in terms of your position. Like nobody should be locked into anything at this point, innocence or guilt. You can't be, because you don't know what the evidence is. And what evidence we do know, it's got to be vetted. I say it all the time. All the time. So, all right. We're going to have to do these things in episodes because they're long. They're long. And this was probably the least interesting of the three. The Franks is pretty interesting, and the DNA one's pretty interesting too. But I definitely want to have Allie on when I'm doing the DNA one. Because she'll be great to have on here. So, yeah, not a chance, Mandela. Not a chance, girl. I think I'm going to go see my boy in Iowa tomorrow if Allie's feeling okay. I don't know. I'm not optimistic. I'm not optimistic. Is that what they're saying? Jury selection starts August 11th. Yeah. I'm gonna hit up. I'd like to try to get like a press pass for that. Yeah, I will. I will. Like, I mean, it has to make sense. Like, no one should be coming to any final conclusions on jack shit until things go to trial. You know what I mean? It's like we get like you can't, like, people that are so adamant about one way or another pre-trial. You just gotta take them with a grain of salt, because we just don't know what the evidence is, and what evidence we do know exists. Thanks, MB. Appreciate you. Thank God there's one. Thank God there's one out there. So, you guys rock. I love you. I love you guys so much. Let's see. I got to give some love out here before I dip, though. And remember, Megan Spitfire, it was funny that you were messaging and emailing about having a schedule, because I swear to God, like pre getting that email from you, I was just telling Mandy and Tracy we're moving to a set schedule. Now, I already screwed it up for next week because we're having Josh on Monday nights. I want to do Monday and Wednesdays earlier, so like 5. Tuesdays and Thursdays are going to be at 7:00. And Fridays, I'm going to do, like, I'd like to do it earlier in the afternoon, because I'd like to give our friends that are across the pond the opportunity to watch where they're not up at the crack of dawn. And then we're all done for Fridays early. So you guys can go enjoy your weekends and do what you're going to do. So, but that's going to be a set schedule. So like when I'm scheduling guests on, it's going to be within those schedules. That way you guys know day in, day out exactly when I'm going to be on. Cause it's like, and obviously if I'm covering a trial, then, we'll have that morning session. I'll still do the night shit, probably. Um, but the trial coverage, I love it. Allie's not as big a fan of it. Yeah, I mean, it depends on the case, but you guys know, like you can watch any case and they're all fascinating in one way or another. Like once you start getting in the minutia of any case, they're all fascinating. That's why people love true crime. We're seeing people are at their worst. It's the human condition on display, full display for all to see. It's fascinating shit. All right, so Idiot Wind. Aw, thank you. Gifted 10DD podcast memberships. Aw, family hug. Appreciate you. Thank you, Idiot. Feel bad. Feel bad not saying the full name. Thank you, Idiot Wind. Lisa, Bob, they just released the transcripts of the closed hearing. I emailed you the file, Bob. They just released the Lisa, I'm assuming that you were voice to text there. Thank you so much. Thank you for both your generosity and for emailing the transcripts. I'm assuming you're talking about for Luigi. I'm guessing. Yes. Thank you for that, Lisa. I appreciate it. SJ, new member. Oh, family hug. Boss lady. Oh, family hug. Welcome, y'all. Papa George gifted 5 DD memberships. Thank you, Papa George. You're amazing. Dom's mom, love you long time. You're the best. Time flies when you're having fun. Love you, Bob. Love you back, Dom's mom. Big time. Okay, so this was interesting. CH had asked, can you explain Hippler stating the full Franks was granted on IGG and denying the Franks? I was a little bit confused about that as well. I think he considered what took place on the front end to be an actual Franks hearing. Because like when I first read it, I'm like, oh, he's denying the full Franks. And then I'm reading it and he's talking about we had a Franks. I'm denying any further Franks hearing on it. So the order wasn't crystal clear on that. When we go through the Franks order, hopefully he'll clarify it a bit. I've browsed through that one. I had fully read this one, hoping there was going to be some tasty tidbits in it in terms of stuff, evidence. We didn't really get it, and I read pretty thoroughly through the DNA. The DNA of the 4 brothers. We'll talk about it when we do that one. It's much ado about nothing. I can tell you that right now, though. Lisa, so if you're a defense attorney and your client tells you they murdered somebody, do you have to stay with them? Do you work for a murderer who just wants to get out of trouble? It's not really how it works. Like the better hypothetical would be that they've arrested somebody that has no evidence, like that, or that they have shit evidence, and then the guy confesses it. Like you're basically talking about like what's that movie with Richard Gere and Ed Norton, where he fakes like he has the stutter, and then like his client, like he finds out that he actually did it, and then he's trying to figure out a way to trip him up. Like in reality, Lisa, most of the times, once you get the discovery, it doesn't really matter what my client tells me in terms of whether they did it or they didn't. I mean, because where I live is in the world of evidence, and the evidence is going to dictate how that trial is going to go. So if you've got a real issue with a client, like in a scenario like that, but I can honestly tell you, forget about murder, just about any crime. Sort of like DUIs. Like I never have anybody confessing that they did it. You know, it's like ever. So it's rarely a situation where, like I guarantee you Kohberger has never admitted to Ann Taylor that he did this. Guarantee it. Not a chance. And then if you've got a client like that where they've confessed, then you go and do your job. You make sure that they get a fair trial. You make sure that the cops did their job right. You make sure that the prosecutors did their job correctly. And at that point, if you make sure that your client understands their rights, you guide them through the process. If there's a plea that's been offered, you bring that to them. You discuss the strength of the state's case or weakness, whatever the case may be. You do all those things and they have the evidence, they're going to get a conviction. I mean, just Google conviction rates. I mean, not guilties are super rare in general. Not guilties on murder cases are even more rare. I mean, like the only two that I can think of offhand, like immediately on straight murder, not self-defense cases, where that's a different evaluation. That's, where their response is reasonable under the circumstances, and were they acting in self-defense? That's a justifiable homicide. That's not murder. So, but in straight murder cases, like OJ, Casey Anthony. I mean, who else can you guys think of that got NGs? Where you're like, oh my God. Like, you know what I mean? It's like, they're very rare. We don't live in TV shows. It's not fiction. I mean, convictions, like if you look at the average conviction rate of prosecutors around the country, it's in the high 90s. So, I mean, in a situation where you have another way to look at it is if you have a feeling that your client did it based on the evidence that you've reviewed, you do exactly what I just said. You go in and you do your job. And you put forth a defense, but most of the time, because it's like you see these cases where there's no option other than to try it because Kohberger's got nothing to lose. I mean, he's standing by his proclamations of innocence, but they're seeking the death penalty. You go to trial on that. There's no downside to it. If they're the state's making an offer that is the max, there's no downside. What? Allison's up here complaining about how long I've been on. Like, come in here. Come in here. Come in here. Wow. She comes in firing. How long have you been on? Like tapping on the watch that she doesn't have on her wrist, like that move. You guys know what that move is? All right, you guys, my wife Beckon's dinner is ready. I'm going to go eat with my family. I adore all of you. I think you're all spectacular people in every single way, because without you, wait, did I thank everybody? Yes, I think I did. All right. Because without you guys know I'm just an old man talking about all kinds of cases. Bye.
Particularity.